on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporters. Any violations of these instructions are punishable by contempt of court. If you would announce yourself for the record, tell me who you represent and whether you're moving or responded in today's hearing.
Good morning, Your Honor. Aaron DuBois on behalf of the plaintiff in this case, BG 20 North Lamar Property Owner LLC. And I have my client's representative, Ms. Teresa Cost.
All right. Ms. Gage, you're here representing yourself? Ms. Gage, you're on mute, so we can't hear you if you're talking.
How do I? Okay, can you hear me?
Yes, ma'am, we can. All right. Just wanted to make sure you're there. All right, Ms. DuBois?
Your Honor, this is an eviction appealed from Justice of the Peace Precinct 1 here in Travis County, Texas. My client, which does business as Revel on Lamar, is seeking possession of the property from the defendant, Marlon Green, in this case, as well as all other occupants. They're also seeking an award of back due rent and their reasonable and necessary attorney's fees and costs of court.
Okay. You call your first witness?
Thank you, Your Honor. Plaintiff calls Teresa Cost.
Ms. Cost, you'll raise your right hand. You solemnly swear or affirm testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Go right ahead.
Ms. Cost, where do you work?
I work at Barvin Management Company.
And is that the management company for BG 20 North Lamar Property Owner LLC?
Yes, it is.
Okay. What's your position there? Sorry, go ahead.
Sorry. I am regional manager.
Okay. So you're appearing as authorized representative of the plaintiff in this case?
Yes.
Are you familiar with the tenancy of Mr. Marlon Green, the defendant?
Yes.
Does Marlon Green reside at 5629 North Lamar, apartment 350, Austin, Texas, 78751?
Yes.
Okay. And that address is within precinct 1 of Travis County, Texas?
Yes.
And is Mr. Green's occupancy based upon a written lease agreement?
Yes.
Okay. Your Honor, I've provided to the court via box Plaintiff's Exhibit 1. I'm happy to screen share that if you'd like.
Yes, please. Thank you. All right, Ms. Gage, any objection to that exhibit?
Yes, sir.
All right, what's your objection?
There was another lease created by Miss Samantha Whittaker, which is no longer with the property. That's not the lease, and also there was no rent upon moving. She used our deposit that was provided by Sunrise Communities and created it to be a rent, but it was no rent, in which her words that she was going to refund us the money back that was provided by Sunrise, but that's not the original or the only copy of that lease. So that, yes, I object.
Ms. DuBois?
Your Honor, it's not a valid legal objection to the document. We're operating to evidence. That's what I have.
All right. Exhibit 1 is admitted.
Ms. Cost, I've shown Plaintiff's Exhibit 1. That is a true and correct copy of the only lease agreement between BG 20 North Lamar Property Owner LLC and the defendant Marlon Green, correct?
Yes.
Okay. Has this document been amended or modified in any way but for my marking of Plaintiff's Exhibit 1?
No.
Is Miss Jennifer Gage, the person appearing in court today, a occupant or a resident under this lease agreement?
No.
Your Honor.
Was the answer no?
That's correct, Your Honor.
Oh, okay.
Ms. Cost, was Marlon Green an employee of Barvin Management, the management company for the plaintiff?
Yes.
Okay. Was his residency at the property contingent upon his continued employment with Barvin Management?
Yes.
And this is evidenced by the associate housing agreement that was attached to the lease. Is that correct?
Correct.
Now I've pulled up page 9 of 12 of the lease agreement. Is this a true and correct copy of that associate housing agreement between the property and Mr. Green?
Yes.
Can you help me?
In anywhere on this agreement was Jennifer Gage or anyone else, I guess, were they party to this agreement?
No.
Now, Mr. Green had a discounted monthly rate due to his employment. Is that right?
Yes.
Okay. Pursuant to box C of the lease, what is Mr. Green's monthly rent amount?
$22.99.
But with his employee discount, was rent $1,744, or I'm sorry, go down. $1,724.25 during the period that he was employed by the
Yes.
management company.
Yes.
Pursuant to paragraph 9 of the housing agreement, did Mr. Green agree that should his employment be terminated, he would need to vacate the property within 3 days?
Yes.
When was Mr. Green's employment with Barvin the management company terminated?
I don't remember, but I believe it was in August.
Okay, does
Don't remember the exact date.
August 9 of 2023, does that sound correct?
Yes.
Did Mr. Green vacate the premises within 3 days of August 9 of 2023?
No.
Pursuant to paragraph 23.4 of the lease agreement, did the defendant hold over in violation of the lease beginning August 13 of 2023?
Yes.
And is holding over a default of lease under paragraph 23.1B of the lease agreement?
Yes.
Ms. Cost, I've pulled up what's marked as Plaintiff's Exhibit 2. Do you recognize this document?
Yes.
Is this a true and correct copy of a notice of proposed eviction that was delivered to Marlon Green on August 15 of 2023?
Yes.
Okay, has this document been amended, modified, or changed in any way but for my marking of Plaintiff's Exhibit 2?
No.
Your Honor, we offer 2.
Any objection to 2? Ma'am? Any objection? What's your objection? I can't hear you, ma'am. You went back to mute. Okay, there you go.
Okay. Again, I have my nephew, which is Marlon Green here. Miss Samantha Whittaker I don't even know how to explain it. I have volunteer legal service helping me right now, but Miss Samantha,
Your Honor, I'm going to object to Ms. Gage to offering any testimony at this time. If she has a legal objection to the document, fine.
Miss Erin, you're not understanding that Miss Samantha did not, from the very beginning, she took our deposit money and used it as rent. She didn't tell us any of that, and my nephew has.
Ma'am, the objection is, this objection is sustained. The Exhibit 2 is admitted.
Thank you, Your Honor.
That's fine. Samantha is nowhere to be found.
Ms.
Is it-
Cost, does
What's the
this-
matter?
She's not there.
Ms. Cost, did this document provide Mr. Green notice that he needed to vacate due to his holdover after his termination of employment?
Yes,
And again, the defendant has not vacated and or other occupants have not vacated the property?
No.
Okay. Ms. Cost, I'm pulling up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
yes,
Is this a true and correct copy of the notice to vacate that was hand delivered to the defendant on August 24 of 2023?
yes,
Has this document been amended, modified, or changed in any way?
No.
Your Honor, we offer Plaintiff's 3.
Plaintiff's 3 is admitted.
Ms. Cost, beginning August 10, the day after Mr. Green's employment was terminated, did he fail to pay full rent for the month of August 2023?
yes,
And his failure to pay rent a default of lease pursuant to paragraph 23.1A of the lease
We
agreement?
didn't pay rent for
yes,
August.
Are you seeking an award here today of back due rent for the month of August in the amount of $765.94?
yes,
Are you also seeking monthly rent for each of the months of September 2023 through January 2024 at the monthly rental rate of $2,299?
yes,
And so for a total between August 2023 and January 2024, is the property seeking an award of back due rent of $12,260.94?
yes,
Has the defendant paid any of those amounts due and owing to the property?
No.
Okay. Ms. Cost, are you aware that 2 other individuals are residing at the property with Mr. Green?
yes,
Did the plaintiff in this case ever provide Mr. Green written approval of other individuals residing at the property?
no,
Okay. Now, going back to Plaintiff's Exhibit 1. Sorry, you're on a screen share. Did Mr. Green agree that no other person but him may occupy the property?
yes,
Okay. Due to the fact that other individuals, other occupants are residing at the property, is that a breach of the lease pursuant to paragraph 23.1B?
yes,
And that's another basis for the property's entitlement to possession of the property for default of lease?
yes,
Your Honor, I've passed the witness. Oh, you know what, Your Honor, I'm so sorry. Ms. Cost, one more question. Are you seeking your reasonable and necessary attorney's fees here today under paragraph 23.5 of the lease?
yes,
Are you seeking interest on any monetary judgment that would be rendered?
yes.
Your Honor, pass the witness.
Ma'am, do you have any questions of this witness?
Yes, I do.
Okay.
Miss Erin, can you submit, if you don't mind? I do have a copy, but I didn't think that this was gonna not be presented. Can you provide the copies that I provided to you and Judge Yvonne's chamber of the check that was received, what myself, my name on it, and Roy Harris's name on it?
Your Honor, I'm going to object to the question. I am not a witness, the fact witness for my client.
But you have a copy. Can you show that to Miss
Ma'am,
Teresa?
let me ask you this question. Was that introduced at the hearing below? Or was it part of the record of the hearing below?
Of this hearing as of today?
Well, I'm asking Mr. Boyd, was any of that done at the hearing below? Were the documents she's referring to actually put into the record of the hearing below?
Well, Your Honor, there was no record at the hearing below.
I'm sorry, were they introduced as, or offered as documents there? You're right, there was no record.
There was documents offered. There was
Is
also
it part of the transcript of the hearing?
I don't know, Your Honor. I objected to several documents at the JP court eviction.
Okay, all right. Ma'am, she doesn't have them with her and she's not required to. So I don't know if they were there or not. And she's not the witness. The lady on the stand is.
I understand that, but I just thought maybe she should share that with Miss Teresa. Being that she's representing Miss Teresa, being that Miss Samantha is no longer there.
Yeah, ma'am, she's not required to do that.
So all the documents that were submitted to Judge Yvonne is not.
I don't know if they are or not. I will do this. I will make judicial notice of the transcript that is in the court below, or was in the JP court, and make it a part of this record. And
Okay.
it's admitted as part of this record.
And may I also ask another question? Well, I don't know if it would be answered or not, but Miss Erin,
Ma'am,
when
you can't ask Miss Erin questions.
okay, so Miss Teresa, were you aware that Miss Samantha refused our rent money? And she was sworn in under Judge Yvonne. When we tried to pay rent back in September, she refused to accept the rent, the full amount of rent. And I have documentation of that.
I am not aware of that specific refusal.
Judge Yvonne is aware of it, and I have documentation of it. She refused to accept the rent, the full rent, not the discounted amount.
Ma'am, as odd as it may seem, her refusal to do so is not a violation. She's not required to.
I understand that. I'm just wondering how it turned into not wanting to accept our rent
because they don't want you at the apartment. They would like for you to leave the apartment. It's that simple.
But then the assistant manager asked me if I would like to pay rent about a month ago via email.
Ma'am, that's not a part of this hearing. This hearing is brought by Mr. Boy in order to evict you from the department you're in now. That's what they're seeking. That's what the representative is seeking, and that's what they're trying to do today.
So everything that Sam did is just, has to be some type of laws or lines in between that.
No, ma'am, they're not.
For the property manager to take our money at the very beginning of moving with my name.
I understand that that's your testimony, but there's no evidence of that before the court. And more importantly, the question is, was the rent paid? That's the real question here.
The rent was paid
They don't have it.
September.
Okay.
Now, whether Miss Samantha was doing something other, I have no idea. She's not here.
Right, and there's a way to do that, but it wasn't done today.
And I'm sorry, Jared Sanchez is the legal person that is assisting me, and he's out with COVID. And this has just happened so fast during the holidays. I tried to get in touch with the courts on last week. Then I tried reaching out to you guys, and then I had to send the email.
Well, I'm sure that if he feels that there was something that I did wrong, he'll be more than happy to tell me.
Right. No, it's not you in particular, but
no, I mean it's what the court's done. But yeah, I'm sure he'll be happy to point it out. But he's not here right now, and we have to go forward with the hearing.
Understandable.
All right. Anything else, Mr. Boy?
Your Honor, I'd just like to testify about attorney's fees.
All right, go right ahead.
My name is Erin DuBois. I'm an attorney.
You want to raise your right hand? You solemnly swear or affirm your testimony about to giving this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right.
My name is Erin DuBois. I'm a licensed attorney. I was licensed by the Supreme Court of Texas in November of 2016. I practice with Rogers Law Firm in and about Travis County, and my primary area of practice is representing multifamily owners and landlords. I was asked to represent the plaintiff in this case and agreed to do so on an hourly basis. I charge $260 per hour and bill my time in tenths of an hour and tasks performed. I have kept detailed records of my time, and in this case, I have discussed the facts of Marlon Green's tenancy with my client's representatives. I have advised them on issuing notices, reviewed the notices in this case, the lease agreement, the associate housing agreement. I drafted the original petition in this case in the Justice Court. I attended 2 hearings in the Justice Court in this matter. I prepared the supplemental petition in this case, the motion under 510.9C that was heard on the 2nd of January 2024, and I appeared in your court on that day to argue that motion. I prepared to conduct this trial and now tried this case. And in my opinion, the tasks I have performed in this matter have been usual and customary, and I am familiar with the guidelines set forth by the State Bar of Texas concerning attorney's fees and the Texas Supreme Court concerning attorney's fees, and believe that I've adhered to these guidelines in all respects. And in my opinion, a reasonable and necessary fee for the usual and customary services rendered on behalf of the plaintiff in this case is an amount of $3,500. That represents roughly 14 hours of my time, Your Honor. If this case were to be subject to a post-trial motion, I believe a reasonable and necessary fee to handle that on behalf of the plaintiff would be an additional sum of $1,000 in attorney's fees. If this case were to be appealed to the Texas Court of Appeals, I believe a reasonable and necessary fee to handle that matter on behalf of the plaintiff based upon my hourly rate would be an additional sum of $5,000 in attorney's fees. If this case were to be subject of a petition for review to the Texas Supreme Court, I'm familiar with the tasks that are necessary to represent the plaintiff in that matter, and based on my hourly rate, I believe a reasonable and necessary fee to handle that on behalf of the plaintiff would be an additional sum of $5,000. And finally, if this case were to be granted a petition for review to the Supreme Court, the task necessary in that matter would be to review clerks and reporters' records, reviewing the appellant brief, preparing a responsive brief, and potentially conducting oral argument. And therefore, I believe a reasonable and necessary fee to handle that on behalf of the property would be an additional sum of $5,000 in attorney's fees. Your Honor, I have provided Plaintiff's Exhibit 4 via box. This is a true and correct copy of my activities export with Rogers Law Firm showing the work that has been done on this case. Prior to today's trial, it was 13.3 hours and the rate was $3,333. With the appearance today here in the trial, we are seeking that $3,500. And I ask that Plaintiff's Exhibit 4 be offered into evidence.
4 is admitted. You rest?
Yes, Your Honor.
Ma'am, is there something else you have to say or want to say?
Not at this time, because I would need the attorney services to help me, because I don't even know how else to explain this. I mean, I don't know. I have no idea.
Okay.
But this was very unethical practices. It's not anything to do with Miss Erin nor Miss Teresa. Miss Samantha, literally, they needed to know who they had working for them. I have a stroke patient. She took advantage of my nephew, knowing he couldn't read well, and I took him in my home, and she offered us, because we were in the process of moving, to move here, and they have no idea who they had working for them.
I understand.
They have no idea. So imagine having to deal with I'm taking care of a stroke patient. I'm making sure my nephew's still on the right track. And as he stated, he would come in and he'd say, "Aunt Jen, Samantha treating me like a slave." And I said, you need to reach out to human resources. He said, when Miss Teresa's there, she do not act that way. And he's sitting right there. And he said, Miss Teresa come to visit the property, she don't act like that. And I said, you need to get the Miss Teresa number or call her off aside. But he's young and he did not do what I advised him to do. So he was under stress and he left. He quit because he couldn't take the pressure that Miss Samantha was putting him under. And then she created all these false documents, and then now she has, I mean, that's just unfair.
Well, ma'am, I think your attorney is probably going to deal with that at some other time. But for today, their motion is granted and the judgment is granted. And I'm sure your attorney will get in touch with them if he needs to and work it out from there. All right?
Yes, Your Honor.
All right. Thank you.
Thank you.
You'll send the appropriate documents. We'll go from there.
Yes, Your Honor, the judgment is in box. Did you want me to e-file that as well or just box?
No, you don't have to e-file it.
Okay.
Box is fine.
The only thing, there's a typo. It says January 23 for rent. It should be January 2024. I can resubmit if you'd like.
No, we'll fix it.
Okay. Thank you very much, Your Honor.
Thank you.
May we